check out riseprofessionals.com/events. You can check out our upcoming leadership summit, May 23rd through 24th in Fort Lauderdale. Now to introduce our amazing panel. Bill Cheney is a partner at Freeman Matheson Gary, Cherry Hill, New Jersey office and is a certified information privacy professional. Bill counsels clients in connection with data security incidents and defends clients in data security and privacy litigation, including data breach class actions. Nick Jaco is a partner at Freeman Matheson Gary, Philadelphia office and is a leader in the firm's data security, privacy, and technology practice group. FMG assists clients in all phases from pre-incident compliance consulting, incident response, breach coaching, and post-incident regulatory and third-party litigation defense. The majority of Nick's experience and the focus of his practice is counseling clients responding to incidents like ransomware and business email compromise events, among others. Keith Bergen has served the legal, insurance, and technology consulting industries for over 15 years in a multitude of roles, including cyber tech and E&O multi-zone practice leader at a global insurance brokerage, coverage monitoring and defense counsel at a national law practice, insurance consultant for private equity clients and their portfolios, as well as an executive leader and director of sales for a restorative and recovery incident response practice at a prominent management and technology consulting firm. Currently, Keith is vice president of cyber claims globally at Tokyo Marine HCC, where he provides enterprise-wide strategic oversight of Tokyo Marine HCC's various cyber claim practices. Jack Zulke is AVP for Professional Liability Complex Claims at Westfield Specialty. Before going in-house, he spent nearly a decade litigating insurance coverage disputes on behalf of various carriers. Tony Dolce is currently the Vice President and Head of Professional Liability, Cyber and Technology, E&O underwriting at The Hartford. He frequently speaks at cyber-related events around the country, authors thought leadership pieces, and serves on several insurance industry groups. Over the course of his 2-decade tenure at Chubb, he handled several cyber and technology matters, including major data breach and privacy cases. Prior to joining Chubb, Tony was an attorney for several years at a large Hartford-based firm, specializing in insurance coverage and commercial litigation. So you are in great hands with this very experienced group, and I will turn it over now to Bill.
Good afternoon, everybody. First, we're going to go through a hypothetical fact pattern to kind of frame our discussion today. Typically when the claim comes in, limited information. So this is, what you would typically receive at the outset. For our discussions today, Acme Company is going to be the insured. And under our hypothetical fact pattern, the CEO of Acme arrives to work to find his company's servers are encrypted and the ransom note that's on the screen. As you can see, the ransom note indicates the network's encrypted. It also says down below that the data has been stolen and the data will be published if the ransom's not paid. The Acme servers under our hypothetical fact pattern have personal identifiable information belonging to approximately 100,000 employees, as well as customer bank account information. No customers or employees at this time are aware of the incident, and the employees reside in Indiana. Acme files a claim with its cyber carrier, and that's where we're going to start off today with claims handling at the outset. So at this point, I'm going to turn it over to Jack. We'll go over that.
Thanks, Bill. And before I dive into it, let me just give the disclaimer that I'm going to be describing the coverages that are usually found under cyber policies, but obviously the terms of any insured's individual coverage, they'll have to read their own policy. But having said that, when the insured calls in this kind of scenario, the most urgent coverage that they're concerned about is going to be the incident response team. Most insureds, when they get this kind of message, have absolutely no idea what they're doing. They are quite understandably panicked, and they need someone to walk them through it. They need forensic vendors who are going to look through the system, figure out how the bad guys got in, what the bad guys have done, what the bad guys have taken. They need restoration vendors who are going to fix the insured system, hopefully without having to pay a ransom for a decryption key, but even if we do have to pay that, to help the insured to use the decryption key to get them back up and running. They're going to need a breach coach to provide legal counsel as to what the insured has to do in this situation and to basically run point over the rest of that. So one of the key advantages of having this policy is not only does the carrier provide coverage for the costs incurred by these folks, but we also, as very repeat customers in this area, can put the insured in touch with some of the most knowledgeable, affordable, and capable people to respond to this. So that incident response team is usually going to be the most urgent coverage provided by that. We next have to let them know that in the event that we deem a ransom payment necessary, that is something that can be covered by the policy, subject to various state or federal laws, specifically OFAC, that I believe Keith is going to get further into. We also let them know that they may have to or desire to report the incident to business partners, to customers, to people whose information has potentially been exposed. The breach coach will usually advise them on that, and if we have to provide that kind of notification and reporting, that also is an expense that can be covered under the policy. We'll discuss business interruption. While their system is locked out, the insured presumably is not doing the business that they exist for, is not making that profit. Some of that can be made up in the weeks or months afterwards. Some of it is a complete lost opportunity, and the business interruption coverage is there to reimburse the insured for that lost opportunity. We'll also provide coverage for public relations and law enforcement. These honestly are probably coverages that don't come up as often. I think of public relations as kind of putting up a billboard or a commercial saying that the incident isn't that big a deal. And usually most incidents are not so public as to require that. Law enforcement communication, likewise, is usually not a major expense. Typically, the breach counsel can call law enforcement, and there's not much of an ongoing conversation, but that is a cost that is covered. As compared to that, sometimes various regulators, law enforcement or otherwise will have a deeper interest in the matter and may issue a request for information, a civil investigative demand, or some other kind of enforcement action, where even if they're not making a specific demand, the insured might have to follow up with a more fulsome investigation into the matter, and the cyber policy will typically provide some sort of coverage to respond to that. And then lastly, if and when third parties who have been impacted by the matter want to bring any kind of third-party claim, the policy can provide for defense counsel to respond to that. So once we've gone through the coverages with the insured and confirmed with them what they do need, what they don't need, what they might not need at present, but may need in the future, there's various information that we'll need to get from the insured in order to understand how best to respond to the situation. Before I dive into the individual pieces of information, I want to preface this by saying that any insured who finds themselves in this situation should call their insurer immediately and not wait until they have all of this. The most important thing is to get your claims handler on the phone and responding to the matter and getting you through this crisis, not to wait until you have all of this information. If there's anything that's missing, you can always follow back later. So once the insured calls with this type of emergency, some of the earliest questions are things like, is the insured system completely shut down? Is it partially shut down, or is it operating as usual? If it's shut down at all, are there backups? Is the insured able to restore its systems in any way, ideally without having to pay the ransom for the encryption key? If the bad guys got into the system, has there been PII or other sensitive information exposed? what's the scope of that information, what type of information it is, how damaging could it be in the wrong hands. We'll also want to know if there's been a ransom demand by the threat actor, and we'll also want to know what the cost of not paying the ransom is. And that means the business interruption cost of the system being down. We'll want to know a statement of work and budgets for the forensic team to get the insured back online. And we'll also want to evaluate the exposure of any third-party claims that can be made against the insured. The next one may be a little counterintuitive for people who don't operate in this area, but we'll also want to know from the breach coach the reputation of the threat actor. Even though we're dealing with criminals, very many of these cyber criminals will want to cultivate a good or reliable reputation as someone who, upon receiving the money, will provide the decryption key and basically be up to their words. So we'll want to know if there's someone who, one, will either provide that decryption key when paid, and two, if it's someone who will refrain from selling or releasing confidential information if a ransom is paid. Eventually, if there is a business interruption claim made, we'll want whatever documentation the insured may have to quantify how much business loss it has incurred. With respect to subrogation, we'll want to know if there are any other parties who might be partially liable for the incident. And then not so much information for the claims handler to collect, but rather than to provide, is that we need to make sure that from the very beginning, the insured understands the mechanics of any ransom should one be paid. Most of these policies are reimbursement policy, meaning that the insured pays first and the carrier will reimburse them. From the very first call, the insured needs to understand that, so we don't find ourselves in some situation in which a ransom has been agreed to on a Friday and a 3-day weekend, and the insured ends up having to wait until the following Tuesday to make that payment. From the very first conversation with the insured, they need to know that if a ransom is paid, they need to have the money ready to go in order to have their system up and running again. So those are some of the most critical pieces of information that a claims handler is going to be collecting. And I'll turn the presentation over to Tony, who's going to discuss the market and underwriting aspects of this.
Great. Thanks, Jack. So having been on both the claims and underwriting side, I just wanted to talk a little bit about what we're seeing on the business side as it continues to change. One of the things that we're seeing is you hear the term hard market or soft market. A hard market generally means that rates are going up and conditions are tightening. The market had been in that sort of state for the last few years, and I think that was as a result of a number of ransomware attacks and larger data breaches and things like that, where folks began to become pretty worried about making sure that they had some type of risk transfer policy in place to cover them in case something like that happened. But we're now starting to see the market soften a little bit, and that kind of dovetails into the advancements in underwriting, in that the insurance market, the cyber insurance market, like in many other industries, helps drive some of the changes in the actual industry itself. And so what I mean by that is that because of the cyber insurance market and pressures on between premium and conditions and things like that, have forced businesses to become better with cyber hygiene. So what used to be a little bit of part of the discussion, whether or not you had adequate backup tapes or adequate segmentation of backups and things like that, or multi-factor authentication, or good training on things like how to prevent phishing attacks and different types of spoofing type of occurrences, that has become much more widespread in the market. And so that has helped the overall cyber climate. And so that's one of those things where the market, I think, helps force some improvements in the overall environment of cyber hygiene. So not to say that cures all the ails the industry as far as, you know, not being amenable to different types of attacks, but just that more and more companies now have incident response plans. They do a better job of backing up their system. So if they are a victim of a ransomware attack, they can get up and running faster, maybe not have to pay the ransom. And using multi-factor authentication or other means to basically make it harder for threat actors to do different types of nefarious deeds, whether it's fraudulent wire transfers or invoice manipulations, or just getting in and spoofing someone or fooling them into doing something that gives them access to the system. So that's I think a positive outcome of what you're seeing in right now in the underwriting market. You know, so the term table stakes is used a lot in this setting, which means, you know, this is minimum requirements now that underwriters are now looking for insureds to have good cyber hygiene and all of these other pieces that make them a better risk to underwrite. Another piece there is, as far as advancements in underwriting, is that, you know, you're seeing a lot of technology being brought to bear by a number of different carriers, whether it's vulnerability scanning, being able to without even going behind an insured's firewall, knowing what kind of vulnerabilities are there, what's their patching cadence, and all types of other things that let you know, almost like a credit score, you know, at a quick glance, what kind of cyber risk they are, and whether or not they're a good risk to underwrite. So that's one of those things you're starting to see more and more of in the cyber insurance industry. One of the other things that it was a big factor that's happened in the cyber insurance industry is over the last few years, and I think some of this has to as a result of some larger ransomware attacks and other attacks, whether it's data breaches or, you know, denial of service attacks or what have you, is the constricting of capacity. A few years ago, it would be commonplace to see most established carriers putting out $10 million in policy limits. Now, $5 million limits are really the new tens. So you're seeing everybody somewhat constrict their capacity, and many folks now are much more comfortable just putting out no more than $5 million in limits as compared to the old 10, or even sometimes even a number even north of $10 million. So those are some of the market dynamics that you're seeing right now come online. As far as the outlook for 2023, I think it's going to continue to be more of the same. You're seeing an increased pressure on accounts and businesses to do more with their cyber hygiene and things like that. And again, you're also seeing cyber insurance becoming very much more ubiquitous in that it's becoming commonplace, like it's D&O insurance or CGL insurance, where the purchaser of insurance for an organization is much more inclined to say, hey, this is a must-have. Just like I have my CGL and my D&O or any other type of maybe business owner's policy, I do need to have some type of cyber insurance to help protect in case there's some type of a loss. So I think that's what you're going to continue to see many more folks, because really one of the biggest groups out there were non-buyers of cyber insurance, but I think you're going to continue to see that number tick downward as more people realize that they really do need this type of coverage. So with that, I think I am going to turn it over to Nick.
Yes, thank you, Tony. So in addition to the changes in the insurance marketplace, we are also seeing a bit of an evolution in the incident response space. So for those of you that may or may not be familiar, my firm, Freeman, Mathis & Gary, as was mentioned in the intro, acts as incident response counsel. Jack also mentioned this, one of many firms out there that will be referred victims of data breach, suspected or actual events, such as ransomware events, to assist those insureds in responding to the incident. And our role, as Jack mentioned, is to act as a quarterback. And there are a few advantages and important reasons why third-party counsel like Freeman, Mathis & Gary would engage or would be engaged by a victim of a data security or a ransomware event. And they really stem from, one, experience, and two, because of attorney work product and privilege considerations. And we say, why does that matter? And really, the role is twofold, especially in responding to a ransomware event that may or may not be impacting an insured's systems and their ability to do their business or run their business. Our primary role is to assist them in getting them what they need under the constraints of their cyber insurance policy to get them back up and running, to get them back where they were prior to the incident. But then also to assess the scope of an incident and assist them in identifying if any legal obligations were triggered as a result of the event. Because as we know, there are legal frameworks out there in all states, globally, in countries around the world, and sector specific that put requirements on insureds who hold sensitive information and sensitive personal information to take certain actions in response to an event if there was unauthorized access or acquisition of data that was sensitive, that belongs to other individuals, or that belongs to business partners. And not only statutes drive those obligations, but they can many times be found in contracts between businesses and business partners. So our role is really to assist the clients, again, quarterback them through that incident response, get them back up and running, determine what obligations they may have, and then not only do that, but assist them in satisfying any of those obligations, whether they be notification to individuals or notification to regulators. Why does that matter? Why do we need breach counsel? Why can't we use our standard in-house attorneys or outside counsel who we use for employment contracts and regular day-to-day business? And that's really because of the privilege and work product protections. The case law out there relating to all litigation, but especially data breach, suggests that if you are continuing to use the same IT firm and the same counsel that you would in any other situation to respond to a data privacy event, that you could not show that there was an anticipation of litigation. In order to show you have a work product protection or attorney-client privilege, you want to show that there is an anticipation of litigation, and there's certain ways you can do that. But essentially, you want to be able to show that your incident response was at the direction of counsel specifically to respond to that incident, and that all your communications with counsel were for the purposes of determining your legal obligations. And therefore, many instances, counsel will engage a third-party forensic investigation firm, not a firm typically used by the insured, to investigate that incident and provide a unattached third-party set of eyes for counsel to evaluate the impact and thereby advise or counsel the insured on what their obligations may be as a result of the findings. As we mentioned, there is a business impact to consider. So while counsel may be, their fees may be covered under the policy, and there may be legal obligations, the primary goal of an insured, may be to consider their business impact. I think we talked about situations where, that insured may hold data relating to its customers or its business partners, who may be the ultimately legal custodian of information of individuals. When we're assessing notification obligations, whether it be to individuals or to regulators, counsel should consider the business impact of putting the organization out there in public and disclosing what would originally be a private event, an incident that may only be known internally to the organization, there to the public, right? Through notification letters, as Jack mentioned, potentially public notification for certain regulations that may require it. So, it's important to consider the business impact, not only with its business partners, but ideally, thinking about third-party class actions and litigation. Excuse me. In the last year or so, the explosion of litigation arising from data breach class action events or data breach events has really changed breach counsel's thinking about how they advise its clients in the incident response perspective. And we could talk a little bit more about that later, but really in determining legal obligations, counsels really wants to advise the clients on what's required. And in the past, it may be that certain findings from a data breach event are not black and white. There's a gray area, and thereby legal counsel is providing advice based on gray areas around what the statute may require and what the findings might show, or what you may be able to prove that did not occur under the statute. Well, previously there may have been more of a consensus to defer to notification, provide the notifications, cover the organization on the back end in terms of compliance. Well, with the growing risk of third-party litigation, now that assessment has changed, where breach counsel may be taking another harder look at the facts, trying to take more aggressive positions on what the law may require, but what really happened in an instance, and thereby ushering clients away from maybe not necessarily notifying individuals or regulators in abundance of caution, but only when there is justifiable evidence to do so. So those are some of the goals that counsel would want to achieve in engaging forensics, right? To get as much information as possible. And certainly, there are coverage implications to think about when engaging a third-party forensic investigation firm, especially in ransomware. Many of the forensic investigation tools will want to, or forensic investigation firms will want to utilize EDR, endpoint detection and response solutions. There may be implications about whether the coverage for that type of tool will continue for the length of a forensic investigation, whether there likely will be not be coverage after the investigation is over. And some carriers even might take a position that that tool added to a statement of work from a forensic investigation firm may not be covered. So during that process, the thinking about third-party litigation, the thinking about what may be covered under the policy for the insured, thinking about the cost of notification in relation to the risks, depending on what the forensic investigation finds. Those are all the considerations that incident response is looking at and counseling the client or the insured during the incident response process. So I think I would turn it over to Keith at this point to talk a little bit more about one of those primary goals of restoring an insured's network from a data security event, from a ransomware event, and how we can assist and how he would assist in those situations.
Thank you, Nick. So incident response, restoration, and recovery is one of the newest iterations in the evolution of cybersecurity and response to cyber incident. Basically, back in 2017, 2018, we really started seeing an uptick in ransomware. Ransomware, traditionally we had seen those Home Depot type of breaches where, millions and millions of PII or PCI were exposed and sold on the dark web. And then we saw a little bit of a shift more towards ransomwares, more towards making a business impact on those who were attacked. So back in 2017, 2018, incident response experts came up with the idea of, yes, Forensics is ultimately important, finding the root cause of compromise, making sure the doors back to locked, and that the threat actor is expelled from a network. That's incredibly important. However, if we don't assist these organizations in helping them restore and recover their infrastructure, their networks, there's going to be a tremendous business impact, both to their insurance carrier as their policyholder and to their organizations. So what happened at the time was a couple groups separately and then a couple groups within forensic organizations started putting together teams that had expertise in infrastructure architecture. So these are the men and women who actually build out these networks for these organizations. So what they essentially do is their primary purpose is to help get business processes back up and running. So restoration recovery experts work hand in side by side with forensic vendors. And while the forensic vendor is shoring up the ship, the recovery and restoration expert a lot of times pulls things off network and begins to rebuild them so that they can get primary business servers back up and running. So for instance, you're a hospital, you can't run your medical equipment, without restoration and recovery. You're going to have to airlift, a higher exponent of people out of your hospital to another hospital. If you have recovery and restoration vendors and they speed to recover that much quicker, they go from, say, it's a week down to 2 days down. You can keep a lot of your patients back in the hospital and get them back on life-saving equipment. An example with retail, if you're an online retailer, you make $1 million a day selling whatever good you're selling, and you're down, you can be down for weeks, you can be down for a couple days, depending on whether or not you utilize restoration recovery vendors appropriately. So one of the issues that we see on the coverage side of this is that the restoration recovery vendor should be pretty fluent in the primary functions of insurance, because one of the things that may happen that you may come up against is the issue of betterment. As they're restoring and recovering, the affected policyholders network, there's a lot of opportunity to improve that network, and your coverage may not necessarily cover those improvements. So that's something that a policyholder really needs to be cognizant of. The insurance carrier needs to be transparent and upfront with those costs. And then the last thing with restoration recovery, there's a lot of different models out there. You'll get one of the primary functions when you're actually in an incident is the restoration recovery specialist will go in and basically supplement internal IT and act as a project manager, where it's basically a recognition that your organization has a lot of proprietary applications. You were affected. I'm not going to tell you that I know exactly how that proprietary application works. However, I'm going to tell you how to operate within an affected environment, how to operate to restore things quicker. So they project manage. Now, a lot of times they're arms and legs to supplement forensics. They can deploy, Nick mentioned EDR, MDR tools. They can help deploy those tools and get them plugged into the network so that the forensic specialists can threat hunt more accurately and more quickly. The different models is you can either have a team full of infrastructure architects, or what a lot of the restoration recovery vendors will do is essentially subcontract or independently contract people from MSPs or MSSPs who have that basic knowledge and can get things moving along. Turning to ransom. So ransom is something that's, obviously as ransomware has become far more widespread, particularly over the last 3 years, between business interruption, exfiltration costs, so privacy costs, regulatory costs, ransomwares are something that everybody needs to be more concerned with, and I think they are. Getting to what Jack alluded to, this is to me most important where time is of the essence. I think from our perspective in my organization, the first things that we focus on are investigating and assessing both the network and the threat acting group. And what I mean by that is, and Jack touched on this as well, you get to learn these threat actors. And some of the threat actors, are consistent. Their decryptors will work. You know exactly where they're going to land in ransom negotiations, things like that. But then you also want to get the right vendors in place. You want to get the appropriate breach counsel to coordinate everything. You want to get the best DFIR vendor for the incident. And what they're basically going to do is they're going to give you an assessment of the environment. So is the environment recoverable? Are there backups? Were those backups affected? A lot of times people say, well, my backup's in the cloud, it's safe. Well, every 10 days, everything from your system gets uploaded into the cloud, which means that if you were affected in that time and you didn't catch it before that upload, now your cloud can be affected. So, you're going to want to know, are you recoverable? Because one of the big things is where we get down to almost the ethical argument of, well, I don't want to pay a bad guy. I don't know, are these people terrorists? Do they come from countries that support terrorism? Versus, I employ 3,000 people, and without getting my business back up and running, we may be out of business. So, you're going to be faced with the threat actor's timeline versus your timeline in making these decisions. So the threat actor is, they're going to hold your feet to the fire. They're going to want you to make a decision in as quick of amount of time as they believe you can acquire and then send them the money. Your timeline is going to be really based on, okay, what can we recover on our own? What can we do to not pay these guys, or these threat acting groups? So you're going to want to see too what the scope is. Have they offered proof of life, where they basically say, hey, listen, we've extracted 1 million privacy protected pieces of data. Okay, prove it. So they'll send you a proof of life, and they'll send you maybe a couple files, or they'll send you a list of all the files that they've actually exfiltrated. So now it's not just recovering your network. Now you have a business decision to make as to whether or not you're going to allow them to expose those records, opening you up to regulatory investigations, potentially opening your organization up to class action, things like that. So again, assessing that environment, understanding what the breadth of the breach is incredibly important, and then going ahead and making that cost benefit analysis. So, what is the ransom? How much can we negotiate that down? And again, this is where, the incident response vendors become incredibly, worth their weight in gold, because most of them will have so much experience with these threat acting groups that they'll be able to go in and say, okay, that's Lockbit. I know that they'll come down at least 25, 30%. So you kind of know where you stand, because now, for the most part, you're going to have to go out and get a vendor. If your DFIR vendor doesn't have a Bitcoin wallet, you're now going to have to retain an additional vendor who will be able to provide the amount of ransom in cryptocurrency and transfer that amount. Those vendors are typically MSBs. So MSBs are highly regulated, and it's as we are about to talk about OFAC and other regulatory bodies, one of the things that you're protecting against is, while you're there's the recognition that we're paying bad guys. So you want to just make sure that you're doing everything in your power not to pay the really bad guys, and to make a good business decision. So leading into OFAC, OFAC is the Office of Foreign Assets Control. And basically, back in 2015, OFAC came out and said, okay, like anything else, if there's a cyber incident and you pay a known organization that is out on our list, called our SDN list, which is their designated nationals and persons list. So basically, it's a terrorism list. And if somebody's on that list, you are not allowed to pay them. And you expose your organization to upwards of 20 million in regulatory fines from the Department of Treasury. So one of the things with OFAC was back about 3 or 4 years ago, there was an incident. Handful of carriers, no one on this call was involved in the incident, and a $10 million payment went out to a threat actor that actually was on the SDN list. So that kind of that made its rounds. That everybody in the industry started talking about it, and it eventually made its way to the FBI. The FBI called a FinCEN exchange. At that FinCEN exchange, which was heavily populated with insurance people, they basically said, "Listen, OFAC to this point, we've never levied an OFAC fine. We're going to start taking this a lot more seriously." And then, we started working together more with law enforcement from that point moving forward. I want to say that was 2019. Forgive me if my date's wrong. But so when that happened, law enforcement said, okay, if you pay it, we want you to start tracking these payments. Well, to track the payments, it's too costly. It's too burdensome to put on an affected organization. So in certain cases, the FBI and other federal agencies have assisted in tracking through blockchain analysis, in tracking where these payments go to try to uncover who these threat acting groups are, who are the players, where are they located, which non-extradition island are they having a Mai Tai on. So that's allowed insurance, and even though it was a bad mistake to pay that money, it allowed insurance, the forensic vendors, and law enforcement to develop a better relationship and to cooperate more with each other when these incidents happen. One of the things that, and I know this isn't what this is, but law enforcement has for years and years been crucial in recovering social engineering payments. So we're working towards that level of efficiency where perhaps we can get to the point where we might be able to recover some sort of ransom payment. But that being said, we're going to get into notice, and I'm going to hand that back over to our legal counterparts. Bill, I think you're taking this one.
Nick's going to be taking it.
Yeah, I'll take it back. Thank you, Keith. And I hope everyone can hear me better. I switched to the headset. I saw that there was a question saying they might not have been able to hear me as clearly on the first round of the presentation. But so moving on to incident response evolution in the notification period. So after, say, we do our OFAC check, we unfortunately maybe have to pay for a decryption key. We get our systems decrypted such that the forensics investigation team can begin conducting the analysis. The incident response attorney and the insured's job is not done, right? We still have to assess the findings and determine whether there are any legal notification obligations as a result of any unauthorized access. And you may hope if you're in a situation like that there was no unauthorized access, but in most situations that's probably unlikely. Unless you were able to, your organization was, had good protections or monitoring in place prior to the incident that could maybe potentially cut off any unauthorized access. Threat actors who gain access to your system for the purposes of encrypting your data to compel you to pay for a ransom note, very often in this climate, in this day and age, in this evolution of data breach and ransomware attacks, will exfiltrate data from your network prior to encrypting your data. And that reason is that because if you were diligent in having offsite backup solutions whereby you don't need to pay for a decryption key, you may also have learned that data may have taken or was stolen from your network in order to have another reason to compel you to pay for a ransom. Because in what's known as double and triple extortion, the threat actors will leave you a note on your system that says, not only do we encrypt your systems, but we took your data, and if you do not engage with us, if you do not pay us, we will release a sample of that data on our shaming site and offer it for sale in the dark web. Depending on the types of data, that may be a compelling reason enough for an insurer to want to engage in negotiations. Counsel typically will advise clients that if a decryption key is not needed, then we should not engage in that conversation and pay the ransom. And certainly there are situations where, an insured will make a compelling argument where I cannot have that for business reasons, that data listed out there on the shaming site or us identified as a victim. That's a discussion where, counsel, the carrier, and the insured have to have about what is the value of preventing data from third-party release. Because as we know, the legal obligations are not triggered when the data is posted publicly. The legal obligations under statute and contract were already triggered when the data left your network, right? When it was obtained by someone without authorization to view that data. So, in operating from that point on, there's a lot of other thoughts and implications that go into place when deciding, okay, say that the statute is triggered, we did or did not pay the ransom, that data was left out there on a shaming site, we have notification obligations, we need to move forward. The thought and thinking behind that will largely depend on the types of data, the incident, how the data was obtained, what your potential notification population is. Depending on what regulatory and legal frameworks may apply, you may have timing restrictions. And those timing restrictions can be very brief and soon, whether they're immediately under contract or a business associate agreement with HIPAA covered entities, or 36-hour reporting requirements to certain regulators. Those timing implications can have an impact on how much or how far your forensic investigation firm will go to identify a root cause, following a decryption event, right? Because we would know that to analyze data and to get a full picture of what actually happened in your network takes time. Analysts need to collect that data from systems, they need to analyze it, and they need time to present it back to counsel and insureds for consideration. So notification events, depending on the timing, may be more specific than possible, right? They may be less specific because timing implications are forcing counsel and insureds to make decisions about whether data was compromised, what data was compromised, and who and what exactly of an individual's data was put out there. If a shaming site doesn't give a full picture, but you have understand that your file site was or your file server was accessed, you may be in a position where you're providing notification to an individual where you're telling them, these are the data points which could have been obtained by the threat actor, and that may be the case even if time were to allow a forensic investigation to go to the end of analysis, right? Because there are anti-forensics efforts that can be taken by a threat actor on the way out the door, right? After they exfiltrated your data, but just before encrypting you, they have ways, tools that would delete logs for a forensic analyst to be able to say, hey, this was done, or these folders and file paths were looked at or accessed during the period of unauthorized access. That will just give you counsel and the insured no visibility into what exactly could have been taken out the door. And many threat actors, are coy, and they'll say if they provide some sampling of data that's going up on a threat actor site, they're going to tell you this isn't all we took. This is just a sampling. So those implications, all types of thought processes and pieces of evidence need to be collected in a short amount of time to help insureds determine, what is my notification population? Who do I have to notify? Where, does it relate to employees? Does it relate to customers? Does it relate to my business partners who I am thereby obligated to notify that their information, which was provided to us, was impacted in an event? Those are all the considerations that we're thinking about. There are also the considerations then downstream, who we are notifying in terms of individuals then impacts what regulators we may have to notify as a result of the event. And what regulators need to be notified then may, by virtue of their funding, their patterns and practices, who may investigate and launch an inquiry. So not only are there regulators that investigate and would send requests for information, some regulators would post the names and the notification letters of insureds that had to notify them as a result of a data breach. And we found in our experience that third-party litigators, plaintiffs' attorneys are scouring these AG sites that publicly shame for potential litigation targets as defendants. So another important consideration when you're looking at the data and you are counsel advising an insured on what their notification obligations may be in black and white or under a gray area under the statute. So I think, Bill, we could probably move forward, understanding we have limited time left.
Yeah, so quickly, don't want to belabor these points. I think Nick addressed some of them, but when during the incident response period, things are changing with the increase of regulatory investigations and litigation. Like Nick said, there's a rise of class counsel scouring these AG sites that publicly shame and looking for these notices. So really, when you're determining whether notice should be issued, should be really taking an aggressive reading of the breach statutes. The breach statutes, like Nick mentioned, again, have gray areas in that, that some of them, provide that, there needs to be a reasonable risk of harm. Well, what does the forensics tell you? What does the evidence tell you? Is the actor in there for that purpose? Are they looking to expose and resell this data? Or are they in there for an alternative purpose? Especially when you're looking at business email compromises, are they in there for, just a wire fraud reason, or are they trying to actually get access and acquire this information? You're also looking at the forensic evidence to limit your notice population, right? The more people you notice, when the AGs are posting that actual the numbers of the individuals that were noticed, you're going to have more eyes on it. You're going to have more class counsel sending out, Facebook advertisements and the like, saying, hey, have you been, notified and have you been harmed? You're also going to want to make sure you're providing sufficient details in the notice. The statutes sometimes constrain what you can and cannot provide, but you want to make sure if there are favorable facts that are discovered, that they are included in your notice, that you are identifying if there are subsets of groups that didn't have their socials exposed while others did. You want to make sure you're drawing a distinction in these notices, because when you see the class action complaints, the real data points that they have and they harp on are from the notices. So, as a defense counsel looking at it, well, then you can rely upon that notice and maybe the favorable facts in there to defeat some of their arguments early on, maybe at a motion to dismiss stage. Some of the other things you want to do is kind of anticipate arguments that you're going to see during these class actions. A typical argument is a future harm argument, that an individual whose social has been exposed is going to be at risk for ongoing harm. Well, so that would be an incentive to offer the complementary credit monitoring. Some state statutes obligate you to, others don't. But this may be a way of limiting your exposure going forward. It can also stop, prevent potential large losses on the other side. Another consideration would be whether to do a dark web search. If you have a ransomware note that doesn't indicate that they exfiltrated the data, the evidence is inconclusive, you may want to do a dark web search to see if it's been posted or published somewhere onto any of these sites, to see what kind of exposure there is there. Again, this is a key argument. A lot of these data breach class actions is that the information is exposed on the dark web. Well, if you've already done this during the incident response, you can counter those arguments pretty timely during the litigation. The last thing you want to do is evaluate the continued storage of the exposed PII. Is it necessary for the business to keep this PII? How long is it old? How long has it been there? Can you maybe take it offline? Can you encrypt it? Are there steps you can take to eliminate or reduce the potential for additional harm and exposure? Because one of the claims that you're going to see in these class actions is for injunctive relief, which can get pretty costly. So if you take these proactive steps, you can again counter those arguments and kind of, set yourself up well in the litigation. So I'm going to now turn it over to Jack, as we just started touching on class actions and litigation, and he's going to go through it on the claims handling side.
Thank you. I'll try to be brief since we're running low on time, but basically say that when the claim is first reported to us, it's usually so far in its infancy that it's rarely the case that any third-party claim has been made when we get that first call. But nonetheless, we're always very aware of that possibility, and we inform the insured that while we can't make any guarantees or promises about coverage until we see those third-party claims to evaluate them, that nonetheless, third-party coverage is something that we provide, so that they need to let us know as soon as any demand, any lawsuit, any arbitration demand comes in, so we can assign defense counsel as necessary. That being said, we're thinking about these third-party claims, these data class actions well before they come in. And that's why we're working with breach counsel from the very beginning to try to prevent or mitigate these claims using the methods that Bill just went over. So I was otherwise going to belabor that, but to save some time, I'll just turn it back to Bill for the details on defending the claim. Oh, and with the point that if we're unable to mitigate the claim such that it actually spirals into a class action, at that point, we'll probably substitute some panel counsel to actually litigate the matter. But nonetheless, breach coaches work in trying to avoid getting to that position is always invaluable.
Thanks, Jack. Yeah, in defending these class actions, like incident response, is an evolving and quickly evolving area. You know, the first consideration that you're giving is whether to remove the action if it's filed in state court. You know, under CAFA, you should be able to, you know, remove it if it's a large data breach and covering multiple, you know, states. Federal judges tend to be more experienced in these types of cases, kind of understand the law, the landscape a little bit better. However, in not all cases are you better off in federal court. You know, it's very fact specific. You know, potentially if you're in state court, it may limit the scope of the potential class based upon jurisdictional issues if you're in state court. Also, you have jurisdictions where the federal court has ruled kind of unfavorably on state law issues and without any state law precedent. They're interpreting what the state courts are going to do. So you may feel like in those cases, you'd be better off before a state judge getting a fresh look at it. They're not necessarily going to defer to the, you know, unfavorable federal decisions. You know, the second consideration is really whether to file a motion to dismiss. You know, I think this is the, you know, standard step in all these cases. Absent kind of unique circumstances, you're going to want to move forward with a motion to dismiss. You know, generally there are just some judges that are not very interested in having these types of cases in their court. They don't find them very, you know, persuasive. They question the damages, they question the basis for these lawsuits, and really push back on the class counsel at the outsets. So even if you don't get a favorable ruling on the motion to dismiss, you can set yourself up really well for potential early resolution based upon some preliminary thoughts or considerations from the court. You know, the avenues that you're going to use to attack on motions to dismiss include standing arguments. If you're in federal court, you're going to be arguing Article 3 standing and alleging that the harm alleged, which typically ends up being this future potential harm, is insufficient to confer standing on the plaintiff. Again, evolving area of law. There was a Supreme Court case, you know, not that long ago, and there was hope that it would go in favor of the defense side and kind of make these cases harder. Although it seems like as time passes, there's more and more avenues for these things to survive Article 3 standing arguments. So the trend is now attacking on the motion to dismiss stage the state law claims. whether there's sufficient facts pled to establish causation and damages. Are the tort claims recognized within the state? Arguing whether there was a breach of the duty owed is somewhat tough at the motion to dismiss stage. Courts are typically going to allow, the general allegations of, well, if they did their job, there wouldn't have been a breach. And the benefits to a motion to dismiss is on the state law claims as opposed to lack of standing. Even if you succeed on an Article 3 motion, you're going to be remanded to state court potentially and fighting the battles again. You may have limited again the class, but you may not have won the day, whereas the motion to dismiss on the state law claims can be dispositive. You also want to look at whether there are any contractual defenses, mandatory arbitration provisions if there's contractual relationships with the named plaintiff, or class action waivers as well. Then you're moving on to, if you're unsuccessful at motion to dismiss, you're looking at to see if you can do some sort of agreed upon discovery schedule that's beneficial to the defense. You don't want to jump right into class discovery if it can be avoided. The motion to dismiss can help maybe set this up. If there's issues with the named plaintiff's claims, you can argue for named plaintiff discovery only, some sort of tiered discovery, and then you would move forward with summary judgment on the named plaintiff's claims before you would get to class discovery. It's a hard uphill battle to get there, but some courts will go that route. Summary judgment, again, when you're at that stage, you're again looking at similar issues: causation, damages. You're looking at the named plaintiff. Have they been harmed by this breach? What is the connection between the harm and the breach? So you're looking at the data points, the time. Have they been exposed in other data breaches? You may want to consider a dark web search on that named plaintiff to see if they've been exposed and if their data has been exposed in other breaches. If you're arguing whether there was a breach of duty, you're going to need an expert. It's going to be a battle of the experts. Unsuccessful or maybe simultaneously, you're attacking class certification. The primary arguments are individual issues are predominating over class issues, mainly as to causation and damages. Again, this is individualized assessments. How do you know, one individual claims they had a fraudulent charge on their credit card? Well, you need to know, was that the same data exposed in this breach? Have they been exposed in other breaches? All these things give rise to individual questions as to causation. On damages, again, you're probably going to be in an expert situation, but how is an expert going to quantify damages on a class-wide basis? How can they identify who has been harmed versus who has not been harmed? All studies suggest that only a small fraction of individuals whose information was exposed in these data breaches actually experienced some sort of harm. They also experience different levels of harm. So attacking the method and manner of class-wide damage calculations, a strong argument at the class certification stage, as well as attacking issues of whether the plaintiff can represent the entire class. Are they in a different relationship with the client, the insured? Did they have a contract whereas others didn't? Is there differing levels of harm? Is there different data that was exposed for different classes of the class? And if all else fails, or maybe at the outset, you're looking to explore settlement. It depends, again, facts, whether you're going to look at an individual settlement or whether you're going to look at a class-wide settlement. Individual settlements sometimes are preferred, but you're also then leaving your client, the insured, exposed on the back end, right? So you're looking at how long has it been since the breach? How much media attention did the breach get? What is the scope of the breach, the number of individuals affected? And if you're going to settle on a class-wide basis, there's multiple considerations that you can have in structuring the settlement. The first is the notice method. Are you emailing or are you mailing the notice? Emailing has been shown to greatly reduce the response rate. When you're structuring the settlement benefits, you're going to want to make sure they're demonstrating their damages, which is an argument that you've had throughout this case. So you're going to use that same argument in settlement, that they need to demonstrate their damages really to drive down the claims rate. The claims rates in these types of cases, if you're offering free money, credit monitoring, you're looking up 1 to 3% response rate. If you're requiring documentation, you're well below 1%. I'll kind of wrap it up there because I think we're way over time. I guess we'll open it up to any questions that we may have in the chat. Seeing none, I think we can end.
Yeah, I want to thank all of the panelists today. This was a very intriguing conversation. I hope everyone enjoyed it. Again, housekeeping for the CE credit. If you need any help, please email us at hello@Rise Professionals. Thank you again to Freeman, Mathis, and Gary, and we look forward to having you all on another Rise webinar. Have a wonderful day, everyone.
Thank you, Amy.
Thanks very much for having us.
Thank you for participating, everyone.